My name is Joy McFarland, and I have been in the industry, just to give you a little brief background about myself, since 1999, March 1st. I've been an administrator for two RAFs, an elder care facility, and then we purposefully shut those down and did supported living. I've also been in charge of a transportation company and a supported day program for an individual who no one would take her to be in a day program because her behaviors were so terrible. I am locating now the sexual harassment training that we're going to do first. Here we go. And let me find it on my share screen. I saved it. Let me find it on my share screen. There it is. Okay. And we will share. Okay. Can everyone see my screen?
Yes.
Okay, perfect.
Yeah.
So this is a mandatory 1 hour sexual harassment training you have to receive every 2 years. No, every year. And it talks about sexual harassment in the workplace. And this is sexual harassment between employees or sexual harassment between an employee and a supervisor or between an individual and an employee or individual and a supervisor. Okay, so I will proceed. I am a trainer that loves to ask questions, and I welcome participation. Okay. I am a natural talker, so I will give examples. I will give examples and I will ask you guys if you have any questions, comments, and would like to participate in the training. I think that a training that is interactive is much more enjoyable than just me sitting here talking for an hour. Okay, so if you have any thoughts, any questions, please ask. Okay, I grew up with no question is stupid. That's my philosophy. No question is stupid. Okay, so we will proceed. Okay, sexual harassment, the facts. Sexual harassment is a form of discrimination based on sex, gender, which now is including pregnancy, childbirth, or related medical conditions, gender identity, gender expression, or sexual orientation. Individuals of any gender can be the target of sexual harassment. Unlawful sexual harassment does not have to be motivated by sexual desire. Sexual harassment may involve harassment by a person of the same gender, regardless of either person's sexual orientation or gender identity. So, what that means is, and I use you guys as examples, so please do not get offended if I mention your name because I just use people as examples and I pick on everybody, okay? I pick on everybody. So, I'm a female, okay? However, I may gender identify as male. And so, Paul, you're there. I see you. I see your name. You may find that offensive. And so you might talk to Beverly, who is your fellow employee, coworker, about me and how I identify as a male. And, boy, I'm tall. I'm almost 6 feet. On a good day, I'm 6 feet tall. So how I'm tall for a female pretending to be a male, right? That is a form of sexual harassment. Okay. So, and with 2024, they've really gone into and they focus more on sex and gender. They've included gender, okay? Because they've seen that lawsuits are coming up that involve gender, gender identity, gender expression, and sexual orientation. So that now is becoming a topic that they need to include in this sexual harassment brochure. Okay? Any questions before I go on? No? And Nellie, I'm going to have you monitor the questions.
Sounds good.
Okay? Thank you. Thank you, dear. Okay, there are two types of sexual harassment. The first one is quid pro quo. And this is Latin is for this, for that. So this sexual harassment is when someone conditions a job, a promotion, or other work benefits on your submission to sexual advances or other conduct based on sex. Okay. So, Dominga, I really like you. I really like you. And, I see that you want to be promoted. Well, we're going to have lunch together and maybe dinner one night. Dominga, if you really want that promotion, that's what you're going to have to do to get that promotion. Okay. That is a sample of quid pro quo. Okay. If she wants the promotion, she's going to have lunch and dinner with me and maybe something else. Okay. In order to get that promotion. Okay. And if she chooses not to, then hey, no promotion. You know, I'll give it to Nellie, okay? Or I'll give it to Michael, okay? All righty, okay? Now, the second one is a hostile work environment. And this has been kind of thrown around about, Joy, she doesn't say hi to me when I come into work, and she'll say hi to Lancia, but she won't say hi to me. She's creating a hostile work environment. Well, that's not necessarily an example of a hostile work environment. And what I like about, again, 2024 brochure, they're defining what a hostile work environment is under sexual harassment. Okay? Um, a hostile work environment occurs when unwelcome comments or conduct based on sex unreasonably interferes with your work performance or creates an intimidating, hostile, or offensive work environment. You may experience sexual harassment even if the offensive conduct was not aimed directly at you. Okay, so this is someone hearing about it in the workplace and they bring it to the supervisor or the agency director's attention. That's creating a hostile work environment. And the harassment must be severe or pervasive to be unlawful. A single act of harassment may be sufficiently severe to be unlawful. So let's talk about those last two sentences, ladies and gentlemen. So, the sexual harassment must be severe or pervasive to be unlawful. So me coming in and not saying hi to Lancia, is not necessarily severe or pervasive. Okay? Now, a single act may be sufficiently severe. So depending on the situation and how it occurred, may be severe enough to be unlawful. Okay? All right. Any questions there, ladies and gentlemen? Okay. All right. I'll continue on. Behaviors that may be sexual harassment. Let's look at them because they define them. Number one, unwanted sexual advances. Okay. Number two, offering employment benefits in exchange for sexual favors. Number three, leering, gestures, or displaying sexually suggestive objects, pictures, cartoons, or posters. Okay. Number four, derogatory comments, epithets, slurs, or jokes. And jokes is the easiest one to cross the border, to cross the line between, just telling a joke or telling a sexually explicit joke that, let me see who I haven't said yet, that Manny may have heard. Okay. And Manny overhears the joke and I'm saying it to Juanita. And so Manny hears it and finds it offensive. Okay, all righty. Graphic comments, sexually degrading words, or suggestive or obscene messages or invitations. Okay, and then finally, physically touching or assault, as well as impeding or blocking movement. So number 6 comes into when the behavior has kind of crossed all these lines. And if you notice, ladies and gentlemen, the behaviors become progressively worse. Okay, they become progressively worse. And number 6 is when I actually touch someone or assault someone, or I'm blocking the door from them leaving the room because that's impeding their walkway or impeding I'm in the middle of the hallway and they can't get around me because I'm refusing to turn sideways or to go ahead and pass them in the hallway. Okay, all right. Are there any questions in this part, ladies and gentlemen?
No, there's nothing in the chat either, Joy.
Okay, all right, thank you. Okay, so let's continue on. All this verbiage, okay? Actual or threatened retaliation for rejecting advances or complaining about harassment is also unlawful. So if if I'm doing sexually harassing you, you can't threaten retaliation or actual retaliate against rejecting it. So you need to appropriately no, I'm sorry, I have that wrong. Um, so I'm doing a sexual act, making a sexual comment, and I can't threaten you because you said no. Okay? I can't say, well, there's your job. Or I'm gonna tell Fred that you did do it and get you in trouble if you don't do it. Okay? Employees or job applicants who believe that they may have been sexually harassed or retaliated against may file a complaint of discrimination with CRD within 3 years of the last act of harassment or retaliation. CRD serves as a neutral fact finder and attempts to help the parties voluntarily resolve disputes. If CRD finds sufficient evidence to establish that discrimination occurred and settlement efforts fail, the department may file a civil complaint in a state or federal court to address the causes of the discrimination on behalf of the complaining party. CRD may seek court orders changing the employer's policies and practices, punitive damage, and attorney fees and costs if it prevails in litigation. So let's talk about that for a minute. And also, employees can pursue the matter through a private lawsuit in civil court after a complaint has been filed with CRD and a right to sue notice has been issued. So let's talk about that for a moment, ladies and gentlemen, so that everyone understands the steps, okay? So when an employee or a job applicant believes that they may have been sexually harassed or retaliated against and may file a complaint of discrimination. And that has to be within 3 years of the last act of the harassment or retaliation. So if I did something to LaWanda in 2025, she had May of 2025, she has May of 2028 to file a suit. Okay? And she can do it with CRD, and CRD they're the independent fact finder. And if they find that I was sexually harassing LaWanda and she was a victim, then they will do a suit, and LaWanda can hire a private attorney and sue as well. And this is why it's very critical, ladies and gentlemen, that you inform your supervisor of anything that you believe is happening to you at work, whether it's sexual harassment quid quo pro, or if it's sexual harassment in our definition of creating a hostile work environment. Communicating with your supervisor is critical. It's critical, ladies and gentlemen. They are not mind readers, so they don't know if something's happening to you and you're not saying anything. It is your responsibility to say something to inform them. Okay? All righty. Any questions there, ladies and gentlemen? Okay. All employers, regardless of the number of employees, so whether Vision Life has one employee or 500 or 1,000, are covered by the harassment provisions of California law. Employers are liable for harassment by their supervisor or agents. So Vision Life is liable if a supervisor does it, if a vendor who comes on to the business office and does it, supervisor, Vision Life is liable. And that's why, ladies and gentlemen, it is critical that if you see something, you need to say something. If something's occurring to you, you need to say something, okay? Employees accused of harassment, including both supervisory and non-supervisory personnel. So the non-supervisory personnel are the SOS instructors. That's you guys, okay? May be held personally liable for harassment or for aiding and abetting harassment, okay? The law requires employers to take reasonable steps to prevent harassment. If an employer fails to take such steps, that employer can be held liable for the harassment. So, if you go to Beverly, to Lancia, Nellie, I believe you're in management, or anyone in management, and you say, hey, this is what's happening. This is what I'm being told by so-and-so. They're trying to, Joy's trying to, ask me to do things. She wants me to meet for lunch. That's your responsibility to tell the supervisor and the owner of the agency, because that puts the ball in their court and then they have to take action against me. Okay. All right. Otherwise, they're liable. In addition, an employer may be liable for the harassment by a non-employee, for example, a client or a customer. And the customer would be, for instance, the FedEx guy. Okay. All righty. Who comes and delivers packages to the office, or the postal carrier, something in that example, okay? Of an employee, applicant, or person providing services for the employer. An employer will only be liable for this form of harassment if it knew or should have known of the harassment and failed to take immediate and appropriate corrective action. Okay. When it's by a client or individual and a customer, a vendor of one of the agencies that provide services to Vision Life. Okay. Employers have an affirmative duty to take reasonable steps to prevent and promptly correct discriminatory and harassing conduct and to create a workplace free of harassment. A program to eliminate sexual harassment from the workplace is not only required by law, but it is all the most practical way for an employer to avoid or limit liability if harassment occurs. So an employer really has to have a zero tolerance for harassment, for any type of harassment or harassing behavior. Okay. Okay. All employers must take the following actions to prevent harassment and correct it when it occurs. Number one, distribute copies of this document or an alternative writing that complies with Government Code 12950. This document may be duplicated in any quantity. So you will see this document posted in the office, okay? Post a copy of the CRD employment poster. California law prohibits workplace discrimination and harassment. That should also will be in the business office. Develop a harassment, discrimination, and retaliation prevention policy in accordance with 2 CCR 11023. The policy must be this harassment, discrimination, and retaliation prevention policy must be, number one, in writing. Number two, list all protected groups under FEHA. Three, indicate that the law prohibits co-workers and third parties, as well as supervisors and managers with whom the employee comes into contact, from engaging in prohibited harassment. Number four, create a complaint process that ensures confidentiality to the extent possible, a timely response, an impartial and timely investigation by qualified personnel, documentation and tracking for reasonable progress, appropriate options for remedial actions and resolutions, and timely closures. Okay. Number five, provide a complaint mechanism that does not require an employee to complain directly to their immediate supervisor. So, if I am Michael's direct supervisor and I am harassing Michael, he should not have to directly report to me. He can report to another supervisor or to Beverly directly. It does not have to come directly through me. Okay, all right. That complaint mechanism must include, but is not limited to including, provisions for direct communication, either orally or in writing, with a designated company representative and or a complaint hotline, and or access to an ombudsman, and or identification of CRD in the United States Equal Employment Opportunity Commission as additional avenues for employees to lodge complaints. Okay. Instruct supervisors to report any complaints of misconduct to a designated company representative, such as a human resources manager, so that the company can try to resolve the claim internally. Employers with 50 or more employees are required to include this topic in a mandated sexual harassment prevention training. Okay. Indicate that when the employer receives allegations of misconduct, it will provide all parties appropriate due process and reaches reasonable conclusions based on the evidence collected. Make clear that employees shall not be retaliated against as a result of making a complaint or participating in an investigation. Okay, and that's really critical, ladies and gentlemen, because a lot of employees who may witness the harassment are afraid to speak out because they think they're going to lose their job. So that's critical. Okay. Distribute its harassment, discrimination, and retaliation prevention policy by doing one or more of the following: printing the policy and providing a copy to employees with an acknowledgement form for employees to sign and return, sending the policy via email with an acknowledgement return form, posting the current provision of the policy on a company intranet with a tracking system to ensure all employees have read and acknowledged receipt of the policy, discussing policies upon hire and doing new hire orientation, and using any other method that ensures employees receive and understand the policy. Okay. Number five, if the employer's workforce at any facility or establishment contains 10% or more persons who speak a language other than English as their spoken language, that employer shall translate the harassment, discrimination, and retaliation policy into every language spoken by at least 10% of the workforce. In addition, employers who do business in California and employ 5 or more part-time or full-time employees must provide at least 1 hour of training regarding the prevention of sexual harassment, including harassment based on gender identity, gender expression, and sexual orientation, to each non-supervisory employee, and 2 hours of such training to each supervisory employee. All employees must be trained by January 1st, 2023. New supervisory employees must be trained within 6 months of assuming their supervisory position, and new non-supervisory employees must be trained within 6 months of hire. Employees must be retrained once every 2 years. So it's 2 years, ladies and gentlemen, that you should be receiving this. Okay. Civil remedies, and this is where people think about when you're taken to court. Oh, I'm going to get some civil remedies, which usually involves some type of the examples they're going to give here. Number one, damages for emotional distress from each employer or person in violation of the law. So, what does damages means? Money. Money for emotional distress from each employer or person in violation of the law. Okay. Hiring or reinstatement of the person because they were fired, right? They were fired. Back pay or promotion. The example that I gave, I believe it was to Dominga. I didn't hire her, right? I didn't hire her because she didn't want to do lunch and dinner with me. So she would get that promotion. Okay, all righty. Changes in the policies or practices of the employer. So when there is some type of lawsuit, there may be policies that weren't covered initially that allowed the harassment to happen. And so this is what looking at the current policies and do they cover an employee who wants to bring forth a charge, okay? To schedule an appointment, contact the communication center below. If you have a disability that requires a reasonable accommodation, the CRD can assist you by scribing your intake or phone, or for individuals who are deaf or hard of hearing or have speech disabilities through the California Relay System 711, or you can contact us below. So, to file a complaint, you can contact the Civil Rights Department. That's the CRD that we talked about earlier. And they give you an email of calcivilrights.ca.gov/complaint process. That's their email address. You can call toll free at 800-884-1684. Or if you're deaf or hard of hearing, the TTY relay system is 800-700-2320. And the California relay system is 711. Okay. Have a disability that requires a reasonable accommodation? CRD can assist you with your complaint. So that's it, ladies and gentlemen. Are there any questions, any comments, any thoughts you'd like to say? Anyone have a comment, a thought? Nellie, does anyone have a comment?
No, they're not in
No.
the chat. Yeah, just verifying. No, they're not in the chat.
All right. Okay. All right. Thank you, ladies and gentlemen.
Did we get
Um,
everybody's name, Joy, that joined? Because I
um,
know some people joined after the fact to make sure that.
don't close the session. I will look at the participants because this is a mixed class. So I
Mhm.
will look at the participants. So if you have an iPhone by your name, young man with the
I
beard, you
couldn't
did not
change it. I
change.
couldn't figure out how to change it. I didn't want to leave and come back in, but I couldn't
Okay.
figure out how to
Now
change
you're
it. Sorry.
young. You're young. young. See, I'm
I
old.
checked
I'm
everywhere.
Stone Age.
Listen,
Okay.
I'll show you how after this. I do
Okay.
have a list of the participants as well. And I
Okay.
also just want to let you guys know there's a second. So I sent out a schedule of all the trainings. There's a second one right after this at 2 p.m. If you're
Mhm.
able to, please join that as well. And I'll send that link in as soon as this wraps up.
Now,
But
Nellie, don't go.
oh,
I
I'm not.
see
I'm
a
here.
I see a Zoom user with a fan on.
Nelly, can you let them know that is this second training, is it sexual harassment or will it be a different subject?
It's
It's
sexual
sexual
abuse and
abuse.
neglect.
And you
Mhm.
guys, they have the schedule with the names of all the trainings.
Okay, sounds good.
Mm-hmm.
Thank you.
A Zoom user with a fan on.
Yes. Do you see that? Do you see that one, dear?
Let me see. Oh, I do see a Zoom user with a fan on.
We do not know who that is.
Don't know who that is. If that's you, oh, you know what? That may be, no, that's not David. If whoever the Zoom user is, the camera is pointing to your ceiling. If you can send me a message letting me know who you are.
Is it that young lady that had the shirt on? No, that's
No.
Lacey.
Leica. Yeah,
Okay,
Leica is
no.
here.
Uh-uh.
Mm-hmm.
No. So we don't know who that is because they will not get credit.
Is that person present right now? Can they come forward and let us know who they are? Zoom
They're
user
on
with the fan?
they're on mute. I don't think that they have their phone in their hands. But I will touch base with whoever that is. And I do have a list of everyone else. Joy, you do as well. So for those who are sticking around for the 2 p.m., you have about 27 minutes, but I'll send that link out for that one.
We were going to do that at 2:30, I thought, my dear.
2:30, 2:30.
2:30, 2:30, not 2, 2:30.
Mm-hmm.
Okay?
2:30.
All right, so you have an hour. Okay? It's been a pleasure meeting you guys. Take care and be safe.
Thank you guys. Please
Thank
send me
you.
a message if you need
Thank you.
anything. See the rest of you at 2:30.
Nellie, I'm going to stay on with you.
Okay, sounds good.
They're so sweet. They're all saying bye.
Yeah, Zoom user. Bye, Dominga.
Thank you for being on
Bye-bye.
Dominga. I'm
Bye,
gonna
Ramona.
the chat. Thank you.
Who's the Zoom user? We do not know.
No,
Okay.
they'll be back in a second.
Okay.
Um,
So,
But
let me
do
look
let me
at,
they?
stop. Give me 1 second. Let me stop the
sure.
recording.
Now, is that La Crystal? Could that
No.
be?